and welcome to Crime in Court. My name is Heather, and this is episode 53 of the Canton Cover-Up Commonwealth versus Karen Reed. We're going to be talking today about what happens when a jury cannot reach a verdict. They're basically getting another bite of the apple. So, this video, we're going to not be reading any case or court documents from the Karen Reed trial, but we're actually going to be reading a scholarly legal paper that I thought was really interesting, and it brings up some really interesting arguments that I wanted to share with you. So, before we get into that, I want to give you an update on lead investigator Michael Proctor, and also I need to update you on what else is going on in the Karen Reed case because even though the trial just ended, there is still more to be to talk about because so much more just happened yesterday. Catch up if you haven't had a chance to catch my video from yesterday. Go check it out. I talk about the motion to dismiss the jury potentially, from Alan Jackson and Yannetti. They uh, put forth affidavits saying that they communicated either with a jury member or an intermediary to a jury member talking about how they actually did come to a verdict on some of the charges. So check that out if you haven't already. I will link it here. You know what? Down below, I'm going to also put a link to my upcoming Innocence Lost episode. It's a so I do a series weekly on people who are incarcerated or exonerated for crimes that they didn't commit. So this this week, a lot of people have been talking about the Trial 4 case or the Trial 4 documentary that's on Netflix. It's about a individual gentleman named Sean Ellis and how he almost went to trial 4 times in Suffolk County, which is a neighboring county of Norfolk County, and he's free now, but I tell his story and read some of his language, and um, it's really powerful. So if you go over, oh, I also share an inspirational speech that he gives. So definitely make sure you are um, subscribed. Is that the right word? Subscribed, notified. Click the notification bell so that you get notifications, that's it. When that episode is premiered, I have it scheduled. I always do a series, an episode for this series, Innocence Lost, on Sundays at 11 a.m. Central Time. So just letting you know. All right, so I'm going to give you a quick update about Michael Proctor. So Michael Proctor, as you probably are aware, was the lead investigator in the Karen Reed case. He said some horrific things about her to his friends, coworkers, family members, just anyone who would listen, apparently. And really just awful. Dehumanized her. And we got to hear all about it on the stand because he got to read those text messages into the record for some reason. I don't know why they got ahead of it, the Commonwealth, or they tried to get ahead of it by having him read all of his horrible text messages, and it really failed. And after that, then, after the mistrial, I should say, after the mistrial of the Karen Reed case. So I feel like if she was found guilty, this wouldn't have happened. But after the mistrial of the Karen Reed case, we got a notification that the Massachusetts State Police were transferring him. Every outlet was saying he was relieved of his duties, but that's very misleading. He was relieved of his position as a detective. They took his badge, his gun, and his car, I believe. Um, so they took all those things, and now he was on desk duty for about a week until he had this status hearing, which is which took place Monday, July 8th. So this status hearing was to talk about his conduct in this case and maybe other cases. I have no idea how far the corruption goes or the misconduct, but here he is, Michael Proctor. All right, so I'm just going to read this quick Boston Globe article. Embattled state police trooper Michael Proctor was suspended without pay effective immediately on Monday after a closed door hearing to determine his immediate future with the agency, officials said. State police officials said Proctor appeared for his duty status hearing before a board of 3 commissioned officers who recommended that Proctor be suspended without pay. Colonel John E. Maughan, who leads the agency, accepted the recommendation, officials say. Primary investigator in the Karen Reed case, Proctor was relieved of his duties as a detective in Norfolk District Attorney Michael Morrissey's office after his crude and demeaning text messages. What about the planting tail light? Everyone reports it as, well, he said some horrible things about Karen, so that's why he's being suspended. No, I think it's because of the close relationship to the Alberts that he didn't disclose to his or to his bosses, or if his bosses knew, then they didn't care, and they're culpable too. So that close interaction or the close relationship with the Alberts that he has, and the misconduct of planting taillights and potentially having others be part of that conspiracy and cover up because somebody, I believe, helped him get that taillight off. I believe he struggled, and that's why somebody had to help him get that off. I believe it was one of the Canton PD, not Proctor, who got the taillight off. So there's that. Anyways, I believe that was from Shauna the Golf said that, going through the motions, Sean McDonough said that one of the Canton, and I believe it was testified to also that one of the Canton PD officers was the one who actually got the taillight off. All right, so where was I? The primary investigator relieved of his duties as a detective for his crude texts, whatever, and all of his misconduct. I'm going to throw that in there because this Boston Globe did not. Neither a lawyer for Proctor nor a spokesperson for his union immediately returned requests for comment. Proctor's removal was announced hours after a judge declared a mistrial in the high-profile case. So just shortly after the mistrial was declared, Proctor's removal from his role as a detective was announced. Just this Monday, though, he was suspended without pay. So Reed, 44, of Mansfield, is accused of striking her boyfriend, Boston police officer John O'Keefe, with her SUV. You know that. All right. So, Monday's duty status hearing was held virtually and wasn't public, a standard department practice. Proctor's superiors had 4 options. Restore Proctor to full duty, which wasn't going to happen. Place him on a limited duty, like desk duty, which they did, then suspend him with pay or suspend him without pay. So they had already moved him to the desk duty, and then about a week later, they had this hearing, and he gets suspended without pay, which is the way it should be. And I think it should have been that way after he got off the stand. Little too late, Massachusetts State Police, but I appreciate the effort. All right, so an internal affairs investigation into Proctor's conduct remains ongoing, officials have said. At the conclusion of an internal affairs investigation, the department may pursue charges that would be adjudicated by the state police trial board. There's a state police trial board that you can have things adjudicated under. That's interesting. So basically, it'll be an internal administrative hearing, just like the hearing that stripped him of his duty, or not stripped, but suspended him without pay. Same kind of thing, probably, except maybe in person, but I don't know. I'm assuming. I could be totally wrong. So there you have it. Michael Proctor, lead investigator or case manager, whatever he wants to call himself. He was the lead investigator of the Karen Reed case, and he is possibly gonna face criminal charges for maybe some misconduct, some taillight planting. That would be good to see, I think, because I think it's necessary. I think they need to make an example out of this case, the Norfolk District Attorney, and just the Norfolk District, period, the Commonwealth. Make an example out of this case and sanction Michael Morrissey and Adam Lally and just bar them. They shouldn't be practicing anymore if they brought this case to trial. And start cleaning house. Start cleaning up your police department or your state police. That is a big, big, big problem in Massachusetts. Not just state police, but Boston, Canton. Apparently, it's all the local police stations too. We need some assistance in getting them on the up and up. All right, so the next thing that I have for you is the impoundment order. So this came out shortly after I recorded my video yesterday of the motion to dismiss and the affidavits in support of the motion to dismiss. So this was Judge Cannoni's response almost immediately after the defense filed those motions. So then this came out, order of impoundment. The Supreme Judicial Court has recognized that the safety of jurors is crucial to the fair functioning of the judicial system and that the justice system owes them the highest degree of vigilance for their personal safety. I don't disagree. This case has garnered significant and divisive attention in Massachusetts. So because it's divisive attention in Massachusetts, which you don't like, it's attention that you don't like, and across the nation. The trial was live streamed on local and national broad streaming channels. The proceedings continue to be the daily subject of commentary on various social media platforms. Oops. People associated with this case have been charged with intimidation. And that is, that's just showing her bias towards Turtle Boy, who has nothing to do with this. But he was charged, might I say, illegally, unconstitutionally, for witness intimidation of these individuals because he did a rolling rally at their houses and protested. As far as I was aware, protesting is a First Amendment right, and that conflicts with the witness intimidation statutes that they have in Massachusetts. So Turtle Boy is being charged with some bogus intimidation charges that are not even real. And most of the stuff that he said, or most of the stuff that they quoted in their charging documents for him, were taken out of context. So pretty much everything was taken out of context. But it's weird that she has to throw that in there. Like she doesn't want Turtle Boy to get these. Almost. It's like this is for you, Turtle Boy, because I don't want you going to these witnesses and intimidating them. I really think so because he has said on his channel he wants to get an interview with them, with some of the jurors, one or any of the jurors that want to talk to him, which I think would be amazing. They do it anonymously if you have to. That would be awesome. Like have him, on camera and then like a blank screen, just with an icon or something in the place, but just hear the voice so we can hear an interview with one of the jurors would be amazing. I think they should do that if they're scared to come forward. And if I do want to point out, so this she says people associated with this case have been charged with intimidation. That's great and all, but you know what? The only people who actually were intimidated were the jurors because Brian Albert was in the I don't know what you call it, the gallery. He was sitting there talking to or sitting there during the jury instructions, which would have been super staring like face on, straight head on at them with his intimidating, scary faces and making faces and like mouthing things and stuff during the closing arguments. It was very bizarre. Not just Brian Albert, but Jen McCabe, Colin Albert, who definitely didn't belong there, and Carrie Roberts, who I still think she's either a pawn or she's lying, one or the other, or both. I don't know. So there's that. So all of those individuals sat there and I think they had the intention their presence was intended to intimidate the jurors to vote guilty or to hold out or something. I really do feel like they were somebody was gotten to, or at least threatened. I don't know. They should have told Canoni if that was the case. Um, but maybe they're scared. So, as I was saying, the only intimidation here is actually from Brian Albert and Jen McCabe and Colin Albert and Carrie Roberts. And I would throw Paul O'Keefe in there with his intimidating stares and snarls and whatever he had going on, staring right back at the jury too, and staring at Karen. Anyways, so this court acknowledges that the names of impaneled jurors who rendered a verdict in a criminal case, must be retained in the court file and made available to the public. That's according to this particular case. The jury in this case did not render a verdict, however. The court concludes that there is a real and present risk of personal harm to the jurors and to the integrity of their service. So she doesn't want anybody getting to them or having them change their minds or something. I don't know. Consequently, the court finds that good cause exists to impound the list identifying the names of impaneled jurors in the trial of this case. The court further concludes that this is a risk of immediate and irreparable injury. What the hell does that mean? Immediate and irreparable injury. Should the list be made available to the public at this time? This order shall expire 10 days from the date of issuance unless otherwise ordered by the court for good cause shown pursuant to Rule 3B of the Uniform Rules of Impoundment Procedure. Signed, Beverly J. Canoni, Associate Justice, Superior Court. Like, that's how much power this woman has. She's in the Superior Court. She's an Associate Justice, whatever that means. It's probably a pretty high position. And she's got I think she's let the power get to her head a little bit. Anyways, so about this, I don't really know what to make of it. I kind of feel like, okay, I can see why she might want them impounded so for their safety, actually, because maybe, people are trying to approach the jurors or whatnot, and they're afraid or they don't want people approaching them. So she has not really it after a trial ends, like it is court record that the jurors' names are released. However, unless a judge does something like this. So she impounded the list of all the jurors' names. I think she doesn't want Turtle Boy or potentially attorneys Jackson and Yannetti going to talk to these individuals. I think she's trying to reaffirm her, you better stay away from these people. Even though these people have something to say. And they approached Jackson and others about it. So, all right. So consequently, the court finds that good cause exists to impound the list of names. The court further concludes that there is a risk of immediate and irreparable. Oh, I read that. Sorry. Buh. All right. So I, when I move it back up, I confuse myself. So that's the order of the impoundment. I think I don't think it's a bad thing to protect them because this trial has become so much of a nationwide sensation. But I do wonder what her motives are and what her intentions are because I feel like she's trying to block specifically people like Turtle Boy and people who have YouTube channels who would love to get a juror on their show or an interview. Um, I think she doesn't want them talking, and I honestly think she may have told them something in the process of her private meeting not to speak because I am shocked and horrified that no juror has come forth yet to tell us their side. But maybe people are scared. Maybe they really are threatened, and not by Turtle Boy, but by an Albert or a McCabe or a Higgins. Who knows? Maybe a Nagel. We don't know. There's a lot out there that could be doing it. So let me know what you think her intentions were for the impoundment. I think she doesn't want anybody talking to the jury, is what I think. I think she doesn't want truth coming out. All right. So now that we're through all the little housekeeping things, let's begin our discussion now of how many times should you retry somebody? So this is actually, I found this paper. Like I said, this is a scholarly paper from Northwestern University Law Review. All these individuals had some kind of something to do with this paper. They're authors or whatnot. I'm not going to read through all their names because there's a lot, but you can see for yourself. All right, so I'm going to read the abstract really quick so you have an idea of what we're going to be discussing and some thought-provoking arguments to think about. So here's the abstract. How many times can a defendant be retried? For those facing hung jury retrials, it's as many times as the government pleases. I'm going to highlight that. I'm going to highlight that right there. It's as many times as the government pleases. If a verdict is not reached, they can just keep coming back at you. Like I said, uh, check out my episode of the trial Netflix documentary, Trial 4 of Sean Ellis. Very interesting how he was almost tried 4 times. There's another case, I cannot remember now what state it was in. Curtis Flowers. If you know, let me know in the comments. I cannot remember for the life of me right now. Curtis Flowers was tried 6 times for a crime he didn't commit because of prosecutorial misconduct and racism as well from the prosecutor. So it's crazy how they can just keep coming at you. 6 times, can you believe that? All the while you're sitting there waiting in prison for your trial. All right, so double jeopardy prohibitions do not apply when juries fail to reach a verdict. So they cannot, the double jeopardy doesn't attach at that moment, not until there is a verdict. So there is theoretically a built-in procedure solution to stop the government from endlessly retrying defendants. Rule 29 of the Federal Rules of Criminal Procedure allows judges to acquit defendants when, quote, the evidence is insufficient to sustain a conviction, end quote. Considering that a hung jury indicates that jurors could not agree on the sufficiency of the evidence, defendants facing hung jury retrials are prime candidates for the rule's application. So people who face a hung jury, like Karen Reed, would be a prime candidate for whatever this rule is of the federal rules where a judge can't acquit if there's insufficient evidence. Meaning, so if there is a hung jury, technically the state or the prosecutor lost because they didn't prove their case. So that's what this paper is talking about. Technically, they lost. It wasn't a win, a total win for you for some reason, but it's a loss for them. Yeah, so there is theoretically this built-in Rule 29 thing. Yet, Rule 29 has not been applied to prevent hung jury retrials. Instead, the Supreme Court has given a government biased standard for deciding whether there is insufficient evidence to convict, stating that a judge must consider the evidence in the light most favorable to the government. This standard, which can force judges to nonsensically conduct the same analysis in perpetuity when juries repeatedly indicate that evidence is insufficient to convict, is not a functional standard. This note proposes a new post hung jury Rule 29 standard. Rather than viewing the evidence in the light most favorable to the government, a judge should view the evidence in the light it is actually viewed by the hung jury, with no bias towards the government, which makes way more sense than why you should favor the government in that case. Right? So, doing so allows a judge to consider a jury's inability to reach a verdict as proof that the evidence is insufficient. So, a hung jury should be proof that the evidence is insufficient, preventing the government from unduly retrying cases where multiple juries have failed to convict. Like in the case of Sean Ellis, where he was tried for the first two trials were mistrials. So why do they get to come at him a third time? You can't prove it in one or two times. Why a third time? Moreover, a Rule 29 acquittal cannot be appealed, meaning this new standard can be applied today even without the approval of appellate courts. So here's our table of contents. And so buckle up, it's going to be a little bit longer of a document, but I think it should go pretty quickly. All right, so introduction. Look me in the eye and explain to me why the government is going to retry this case. An exasperated Judge Philip Brimmer demanded an answer upon hearing that the government planned to retry United States versus Penn, a case in which broiler chicken industry executives were charged with conspiring to fix prices. The case had already been tried 2 times. 2 times the jury hung, just like Sean Ellis. So these footnotes are um, not, I'm not going to read them because they're not important to my non legal mind. All right, so Judge Brimmer was doubtful that the government could secure any convictions in a third trial. The evidence couldn't persuade 12 people. We've seen it happen twice. Despite Judge Brimmer's hesitance to try a case again, a third trial commenced. Why? Oh, you know what? Let me shrink myself just a teensy bit so I'm not in the way. Okay. So despite his hesitance, they went to a third trial. Following the deliberations, the jury found the defendants not guilty. It took 3 trials and 21 weeks of total trial time for the justice system to officially conclude what 2 juries had already indicated. There was insufficient evidence to convict. So that is a hung jury, basically is an this definition right here. There was insufficient evidence to convict. So why are we going at them again and again and again? It doesn't make sense to me. Does it make sense to you? Because the government can just keep coming at you. They have the benefit of everything, the power behind them, the money behind them. They have law enforcement behind them. They have it all. And in most cases, people can't afford to defend themselves. And they get public defenders, which there are some really great public defenders. Not saying that there aren't, but public defenders can also be overworked, which means that things can get overlooked in cases easily. So that's it's unfortunate. Anyways, so Yeah, could the clearly skeptical Judge Brimmer have stopped this third meaningless trial? Currently, no. While the Constitution prevents a defendant from being twice put in jeopardy for the same offense, the Supreme Court long ago concluded that hung jury retrials do not violate the double jeopardy clause. But, like, why? Why not? Without this double jeopardy protection, defendants facing multiple retrials post hung jury are at the whim of a government that can choose to retry the case as many times as the jury hangs. So you could have hung jury 14 times. I mean, I'm exaggerating, but they can just keep coming at you. There's no rule to stop it. This is insane. Why do we allow this in our country? Period. It's stupid. But okay. That's why I wanted to bring this paper to you because I think it has some really great insights. The federal rules of criminal procedure contain a solution to stop the government from endlessly retrying frivolous cases, Rule 29. This rule allows the judge to acquit a defendant for which the evidence is insufficient to sustain a conviction. While hung juries could be considered probative in determining what the evidence is insufficient to convict, in determining that the evidence is insufficient to convict, the current insufficient evidence standard only allows judges to consider evidence from a perspective that markedly favors the government. That is, in the light most favorable to the government. That's the legalese language. So, putting a thumb on the scale in the government's favor significantly blunts the impact of a rule designed to address fairness and efficiency concerns. Thus, even Rule 29's built in solution has been foreclosed to defendants facing retrial after a hung jury. This government biased standard is not only present in the federal courts, several states have adopted substantially similar insufficient evidence rules and the federal light most favorable standard. Considering that the vast majority of criminal trials occur in state court, a less government favored insufficient evidence standard would provide even more relief to state defendants caught to hung jury retrials. This note argues for a new Rule 29 standard in the wake of a hung jury. Part 1 explains how the current double jeopardy clause doctrine fails to prevent hung jury retrials and considers the pitfalls in two previously proposed solutions. Part 2 introduces Rule 29 and explains why the current insufficient evidence standard fails to stop hung jury retrials. Part 3 proposes a new rule, insufficient evidence standard, that provides judges with more power to stop retrials after a hung jury. Blah, blah, blah. Okay. So, part 1, the double jeopardy roadblock. This part's examination of the current law concerning defendants facing hung jury retrials proceeds in two sections. First, it analyzes the Supreme Court's double jeopardy clause jurisprudence and how it fails to protect defendants facing retrials after a hung jury. Secondly, it considers two previous proposals that have attempted to provide greater protections to post-hung jury defendants, reinterpreting the double jeopardy clause precedent and utilizing judges' inherent authority to stop retrials. A. The cemented doctrine. Do you guys think this is interesting? I think it's fascinating, and I just really thought that this paper had some really excellent points, and um, I always loved in my master's program reading uh, educational papers and things like that. And you know, um, I also, with my medical issues that, yes, I'm going to talk about on my channel. Somebody didn't like that I talk about my medical issues, but it's who I am. And it affects my everyday life. So I'm going to talk about my medical issues. But anyways, trying to come to a diagnosis to all my medical issues because it took years and years and years. And my symptoms kept changing too, so it was hard to keep up with what everything was. So I had to read a lot of medical papers and things like that. So I find it fascinating to do this part, like the research and looking into it, looking into research papers and stuff like that. I don't know. Let me know if you guys like this episode. If you do, please give it a thumbs up. If it's not for you, that's okay. But let me know if you like the other ones better. When I am specifically on Karen Reed, that's fine. I'm only going to do this once in this series. I just thought it would be interesting to bring these topics up, and then you guys can talk about it too in the comments about what you think regarding this paper and their arguments. All right, so since 1824, the Supreme Court has consistently held that retrials after a hung jury do not violate the Double Jeopardy Clause. The foundational case is United States versus Perez, in which Justice Joseph Story declared that a hung jury implicates the manifest necessity to discharge the jury, declare a mistrial, and retry the defendant to achieve the ends of public justice. So this is coming from an 1824 case from the United States versus Perez. Excuse me, hold on one second. Sorry, it tickled my throat and it was really not fun. All right. So we're going back to I said it again. An 1824 Supreme Court case, United States versus Perez. And because this particular justice wrote in it these words, he declared that Justice Joseph Story declared that a hung jury implicates the manifest necessity to discharge the jury, declare a mistrial, and retry the defendant to achieve the ends of public justice. So this single paragraph, 444-word opinion failed to elaborate on what this manifest necessity standard entailed, nor did it explain why the ends of public justice warranted circumventing the Double Jeopardy Clause. Despite this dearth of analysis, Perez's holding went unquestioned by the court for the next 160 years. Why? Why can't we question this? This is stupid. Let's look at the things that we're doing here. Let's not just keep doing it because it's the way we've always done it. Let's be logical and sensical. And yeah, it baffles my mind because he said that this manifest necessity, which whatever the hell that is, and what's the ends of public justice? Why is that need to be circumventing the Double Jeopardy Clause, as they put it? It doesn't make sense to me. Citations to Perez became routine. It had been upheld so many times that the court never felt the need to justify its holding. So we're just adhering to this particular justice's way of thinking in 1824, and no one's questioned it since. Well, maybe they have, but nothing's been done about it since. So this changed in 1984 with Richardson versus United States. The court found itself in a doctrinal bind. Doctrinal? I've never heard of it in that form. Anyways, 6 years prior to Richardson, a unanimous Supreme Court held in Burks versus United States that the Double Jeopardy Clause barred retrials if a judge deemed the evidence insufficient to convict. The implication of Burks on hung jury retrials were obvious. If a judge's determination that there was insufficient evidence prohibited retrials, why wouldn't a hung jury's inability to find the evidence sufficient to convict also implicate the Double Jeopardy Clause? Doesn't make any sense. So this was the question that the court was forced to answer in Richardson. To shore up, so what year? 1984. To shore up Perez's holding in the face of Burks, Justice William Rehnquist gave a novel explanation for why hung juries do not implicate the Double Jeopardy Clause. A hung jury is not a verdict that terminates the original jeopardy. Yet, even this new reasoning turned on old logic. When pushed to explain why a hung jury failed to terminate jeopardy, Justice Rehnquist's only response was that holding otherwise would contradict previous cases such as Perez, an 1824 case that we're still saying is justifiable for reasons that are unclear. Rehnquist was not shy in admitting that his majority opinion relied more on precedent than reasoning. Well, there you go. Rather, he embraced it, stating that a page of history is worth a volume of logic. What? So we should just go along with what history says and throw logic out the window? That's stupid. This continued reliance, I'm sorry, this stupid. This continued reliance on the authoritativeness of Perez, devoid of critical analysis, has given the now 2-century-old case a life of its own. Hung juries are no longer just the first example of the manifest necessity to discharge a jury. They are now the prototypical example of the manifest necessity that allows for retrials. So stupid. In its current state, the double jeopardy clause doctrine provides no relief for defendants facing retrials after a hung jury. Crazy. I, you know, doing this, like, I try to put myself in other people's positions or, I try to think of myself in other people's shoes a lot of times. And when I look at the law, a lot of these laws don't make any sense. It's not like how you would want to be treated. If the roles were reversed and you were the one on trial and the government kept coming after you repeatedly, would you want to allow for them to come at you after a hung jury? The answer, of course, is no, because obviously they failed to prove their case. So why in the hell are we going after people that a mistrial has been um, granted or um, there's a mistrial because of the hung jury? The juries couldn't decide. They couldn't all definitively get there to a guilty. So obviously, state failed, and we shouldn't have to be put back on trial for that. Alternative ways, like I said, put yourself in that situation. If you think it's right to just keep coming after somebody after a hung jury, put yourself in that situation and think about how you would feel. I mean, I'd be pretty pissed. All right, B, alternative ways around. Legal scholars have proposed multiple ways to circumvent this ossified double jeopardy clause doctrine and prevent undue retrials. I surveyed 2 proposals here, rejecting Perez and leveraging the inherent authority vested in judges. That, my friends, is something that, excuse me, that's why I was like choking earlier. Judges don't give themselves the power or the authority that they should have in making logical and reasonable decisions, yet they sometimes overstep their authority in other ways, like being extremely rude and in Judge Cannoni's case, being extremely rude to the defense, which technically isn't like misconduct, but um, favoring the prosecution and holding Lolly's hand the whole time. Like, that's pretty crappy. Her authority, using her authority to help the state prosecute. Number 1, representing Perez. One suggestion is for the Supreme Court to outright reject Perez's manifest necessity exception to the double jeopardy clause. Despite the court's continued reliance on Perez, its holding is incongruent with the purpose of the double jeopardy clause. Exactly. What we'd have to like rewrite history. Oh my God, how should we ever live? Didn't we just like upend the whole Roe versus Wade? I mean, why can't we ixnay Perez? Let's get rid of him. So it's first, retrials after a hung jury pose the same ordeals to double jeopardy clause is meant to protect defendants from. Justice Hugo Black described the purpose of the double jeopardy clause as follows. The state, with all its resources and power, should not be allowed to make repeated attempts to convict an individual for an alleged offense, thereby subjecting him to embarrassment, expense, and ordeal, and compelling him to live in a continuing state of anxiety and insecurity, as well as enhancing the possibility that even though innocent, he may be found guilty. That's powerful. The embarrassment, expense, ordeal, anxiety, and insecurity all continue when a defendant is retried after a hung jury. The possibility of a wrongful conviction also increases with further trials as each subsequent retrial drains the defendant's resources. Not only that, but judges can see how they ruled if you have the same judge on the case for multiple tries, multiple trials, and they can change some of their rulings. They can allow some things in and some things out. Like in the Menendez brothers trial, the original case, the defense was allowed to put on their defense of what they called like the battered wife syndrome back then. But, growing up in that traumatic um, environment where you're mistreated constantly by your parents, it's traumatizing. Anyways, um, they went back on trial. My point was so the first trial, they were able to defend themselves with witnesses that could speak about trauma and expert witnesses on that topic and how to deal with that, the outcome of living in a home like that. And by the second trial, after that mistrial, because it ended in both trials ended in a hung jury. There were two juries in the Menendez brothers case, one for each brother. So both juries ended in a mistrial, and the state was able to come back, try them again 2 years later, and they changed their whole defense, or not defense, but state changed the way in which they wanted to prosecute, and they put in motions to exclude all of these experts and people that really helped prove the boys' innocence. Not innocence, but the fact that they were in a traumatic environment and they feared. They were constantly fearful and fearing for their lives. They weren't able to put on that defense. And that's something that I worry about too with the Karen Reed case is that, okay, Judge Cannoni is going to learn from her mistakes in this one and she's not going to let in certain stuff in the next one because she can do that. She's got the power. It's bull crap. All right, so the embarrassment, expense, ordeal, anxiety. The possibility of a wrongful conviction also increases with further trials. So, a possibility of a guilty, like I said, Menendez brothers, I'm scared that the judge will rule something else out and they won't, Karen Reed won't be able to defend herself as well in the next trial. Defendants under pretrial detention can be forced to remain in detention after a hung jury until a retrial results in a verdict. So that means if you're in jail, you could still be sitting in jail until another trial reaches a verdict, which is crap. As Professor Carrie Leonetti documents, these defendants incur the further immense costs of prolonged detention despite being potentially innocent. Stigma, the isolation of being cut off from friends and family, loss of employment, loss of liberty, the impairment of the ability to mount an effective defense, the degradations of impairment, and threats from other inmates, violence, or even the R word. I'm not saying that. All right, Perez's manifest necessity exception ignores all of these burdens. So yeah, Perez is just like, to hell with all that. To hell with all these things that we're doing to the person. Let's just keep coming at them. Second, Perez's holding is so far outside the bounds of the double jeopardy clause that scholars have questioned its precedential value. Justice Story's opinion, so the justice's opinion, never mentioned the double jeopardy clause nor the Constitution, calling into question whether Perez really was about the double jeopardy clause. Professor Janet E. Feinlater argues that Perez is better read as deciding whether a judge could discharge a jury prior to a verdict at all, as discharging juries before they reached a verdict may or had been controversial at common law. So, but if you don't discharge a jury when they're saying that they're in an impasse, you're forcing them then to come up with some kind of compromise or something, which is not good either. If Perez were to be reinterpreted as solely addressing the issue of discharging a jury, then this foundational case would no longer support the conclusion that hung juries do not violate the double jeopardy clause. The manifest necessity exception would no longer make retrials after hung juries immune to the double jeopardy protection. Unsurprisingly, the Supreme Court has not been willing to disturb such a bedrock double jeopardy clause principle. So the Supreme Court doesn't want to change it, of course. The court has acknowledged that Perez is likely not a double jeopardy clause case and shrugged off the insight as insignificant. To cast such new light on Perez at this later date would be of academic interest only. No, it wouldn't. So we're just going to continue to do things wrong because to hell with finding out the truth. We're just going to do it because we've been doing it that way always. Even if the Supreme Court's precedents are faulty, the court has good reason to avoid ruling that hung jury retrials violate the double jeopardy clause. If a retrial after a hung jury implicated double jeopardy, a blanket rule would be established that would make any hung jury retrial unconstitutional. One oft-cited risk of such a rule is that it would allow one unreasonable juror to hang a jury and prevent future retrials, robbing the government and public of justice. While the concept, well, I see what they're saying, but I still feel like it's better to not come after people constantly and repeatedly and drain them of their life, their resources, their money, their liberties, everything. While the concept that juries often hang because of one intran the in, intransigent what? I can't even pronounce that. All right, hold on. I gotta look it up. Where'd my phone go? That was a doozy. Holy moly. I can't say words. There's a lot of big hard words in this. I'm surprised I'm just looking up words now on this page. Intra intransigent. Intransigent? Maybe that's how you pronounce it. Yes, intransigent. I finally figured it out. Intransigent. There you go. Intransigent means unwilling or refusing to change one's views or to agree about something. So that's an intransigent. All right, we learn something new every day. I love it. Okay, so while the concept that juries often hang because of one intransigent juror has been contested, the public still has an interest in fair trials designed to end in just judgments. For these reasons, this note does not argue for a blanket prohibition against retrials after hung juries. The current double jeopardy clause standard may unduly ignore the interests of defendants, but a solution that ignores government and public interests is not a true improvement. Number two, inherent authority. Another suggestion is for judges to exercise their inherent authority to stop undue retrials after several hang juries. The theory that judges have inherent supervisory authority over criminal justice was popularized at the Supreme Court in McNabb versus the United States. McNabb held that the Supreme Court has supervisory authority over the administration of criminal justice in the federal courts, allowing it to create restrictions on criminal justice beyond what the Constitution provides. While McNabb only confirmed the Supreme Court's inherent authority, lower courts have followed suit and invoked their inherent authority over criminal justice as well. In the context of the hung juries, the Supreme Court in Arizona versus Washington hinted at a court's inherent authority to stop retrials even if the double jeopardy clause permits them. Justice John Paul Stevens stated that if the first trial is not completed, a second prosecution may be grossly unfair due to it implicating the same issues the double jeopardy clause is meant to protect against. Exactly. Exactly. The second prosecution increases the financial and emotional burden on the accused, prolongs the period in which the defendant is stigmatized by an unresolved accusation of wrongdoing. So, like, still, people are saying Karen Reed's still guilty because even though we all saw the trial and there's no way in hell she did it, because it's unresolved, people are still saying, well, see, she did it because people couldn't come to a conclusion, and may even enhance the risk that an innocent defendant may be convicted. So she might be convicted next time around. Doubtful, but it's possible. It's always possible when put it up against someone else's, put it in someone else's hands. Let's say that. All right, so some district courts have found an inherent authority to stop grossly unfair retrials after multiple hung juries. In the United States versus Ingram, the D.C. District Court sua sponte dismissed an indictment with prejudice after two trials resulted in hung juries. When the government challenged the court's power to dismiss the indictment on reconsideration, the district court rejected the challenge, stating that their intervention was required in the interests of justice and it was simply a matter of fair play that the government received no more chances to convict. Wow. I mean, congrats uh, um, to that judge who said that. Um, so basically, the indictments were dismissed and the state can't come back at them after two trials resulted in hung juries. So the government objected to that, and then um, the district court came back and said, no, we're not going to reconsider because intervention was required in the interest of justice. It was simply a matter of fair play, and the government received no more chances. No more chances. So a district court had to step in and put a kibosh on it. But I think that that's right and it needs to be done in more cases. In the United States versus Rosoff, a court in the Central District of Illinois, shout out to Illinois, I'm in Illinois, was faced with a similar situation. Two trials resulted in hung juries on 5 of the 13 criminal counts. Citing Ingram, the court sua sponte dismissed with prejudice the remaining 5 counts, stating that the defendant had been under great physical and emotional strain as the result of these repeated trials, and that the government should not be given continued bites at the apple. Exactly. Finally, in United States versus Wright, a court in the Western District of Pennsylvania was tasked with deciding whether to allow the government to try a defendant a third time after 2 hung jury retrials. After an analysis of both Ingram and Rosoff, the court concluded it had the inherent authority to dismiss an indictment following multiple mistrials, and dismissed the indictment with prejudice due to violating fundamental fairness. So, with prejudice just means they cannot come back at you. Without prejudice means they could. They could try again. The state could have another bite at that apple. So, despite these examples, cases in which federal judges have invoked their inherent authority to stop retrials after a hung jury are exceedingly rare. The Not too many judges want to be that oddball that says, I'm going to I'm going to express my authority and drop charges on someone, especially when it is in a case of a Boston police officer's homicide. They're not going to want to drop that. A recent Supreme Court ruling on district court judges' inherent authority will only make them rarer. In Dietz versus Bolden, the Supreme Court clarified certain limits on a district court's inherent authority. Justice Sonia Sotomayor listed two requirements for invoking inherent authority. First, it must be a reasonable response to the problems and needs confronting the court's fair administration of justice, and second, it cannot be contrary to any express grant of or limitation on the district court's power constrained in a rule or statute. These principles spell doom for the usage of inherent authority to dismiss indictments after a hung jury, as Federal Rule of Criminal Procedure 31B3 gives the government the right to retry a defendant after a hung jury mistrial. If the jury cannot agree on a verdict on one or more counts, the court may declare a mistrial on those counts. The government may retry any defendant on any count on which the jury could not agree. That's important in the Karen Reed case in the sense that we are hearing now that the jury actually did find Karen Reed not guilty on counts 1 and 3, while count 2 was still up in the air. They couldn't decide on that. So, in all actuality, they should have been able to finalize their form and say we're hung on these, or the court should have polled them, asked them, are you unanimous in all 3 counts? One of the count, how many counts? And she should have verified that because you cannot be retried after you've been acquitted. And if she would have been found not guilty in those counts 1 and 3, that's a not guilty for her. Um, and that's a verdict. So then double jeopardy does attach for sure. Even if Rule 31B3 is not considered an express limitation on a district court's judge's power, the rule seems to give the government full authority to retry defendants after a hung jury mistrial, thus creating a presumption against the use of inherent authority. The Third Circuit's reversal of the previously mentioned Wright case illustrates how the current inherent authority doctrine is hostile to indictment dismissals after a hung jury. The court began its analysis by remarking that there is nothing in the text of Rule 31 that empowers a court to prohibit the government from retrying a case. It then went on to consider the Dietz principles, starting with the first requirement that inherent authority must be a reasonable response to the problems and needs confronting the court's fair administration of justice. So there has to be a reason to there must it must be a reasonable response to what's happening to justice, the administration of justice. It has to be you can't just invoke it before you find that it is within the right to do so um, that that's the right outcome, I guess. All right, so whatever, you know what I'm saying. All right, so on its face, the requirement, I hope you know, the requirement appears to favor the use of inherent authority in post-hung jury retrials. Arizona versus Washington already described how a retrial can be immensely burdensome on the defendant to the point of being grossly unfair. Yet the court limited the first Dietz requirement to only allow the use of inherent authority if the government engaged in misconduct, the defendant was prejudiced, and no less severe remedy was available to address the prejudice. It then further limited prejudice to actions that place a defendant at a disadvantage in addressing the charges, stating that there is no prejudice to. Sorry, dry throat again. Like, bad. All right, sorry, I lost where I was. It has further limited prejudice to actions that place a defendant at a disadvantage in addressing the charges, stating that there is no prejudice to the defendant simply because the defendant faces the anxiety of undergoing a trial. Writing off the burdens of defendant faces due to retrials is as inconsequential. The court found the first deeds requirement has not been met. So just the anxiety and stress of going to court isn't enough. That's what they're saying. Next, the Third Circuit moved on to the second deeds requirement. The exercise of inherent authority cannot be contrary to any express grant or limitation on the court's power contained in the rule or statute, asserting that the decision to try or retry a case is at the discretion of the prosecutor and that there is in an absence of power of the district court to dismiss the indictment in Rule 31B. The court concluded that not only was the inherent authority to dismiss indictments after a hung jury mistrial not statutorily supported, it was also directly limited by the Constitution's separation of powers. So, because of that, they are very limited, judges, in what they can and cannot do when prosecuting a case, supposedly, according to this. But I still think that they have a lot of power as to what comes in and what doesn't, and uh, whose witnesses can come in and things like that. They have a lot of power in that way to um, sway a jury. Maybe even, doing some kind of shifty, shady jury form that has no not guilty box on it. Doing things like that doesn't prevent you from doing that. Anyways, separation of powers. Thus, the second deeds requirement was also found to be unfulfilled. Finding both deeds requirements unsatisfied, the court reversed the indictment dismissal and remanded. Third Circuit is currently the only federal appellate court post-Dietz that has ruled on the use of inherent authority to dismiss indictments after a hung jury mistrial. The only other circuit that addressed this use of the inherent authority prior to Dietz was the Ninth Circuit, and it too held that inherent authority could not be used to dismiss indictments. There's a lot of conflicting things within the law. So, what is it? It shouldn't be used for indictments, or it can. Let's make up our minds here. So, it is unclear how a defendant facing multiple hung jury retrials could overcome the Dietz test, especially under the Third Circuit's restrictive interpretation, which has already been adopted by district courts. Considering the sparse number of cases supporting the use of inherent authority to stop retrials, the currently unfavorable Supreme Court inherent authority doctrine, and the circuit court's unwillingness to prohibit retrials, it seems unlikely that the inherent authority of district courts can provide relief to defendants facing retrials after a hung jury. The proposals discussed above each have their pitfalls. Establishing that hung juries implicate the double jeopardy clause would require the Supreme Court to overturn 2 centuries of precedent, which, why not? Roe versus Wade. Who cares? Let's just turn stuff over. I'm fine with it if it makes sense. Anyways, would require them to overturn 2 centuries of precedent, and it would ignore the interests of the government and public. Similarly, while the inherent authority doctrine allows judges to prevent retrials following a hung jury on a case-by-case level, the current Supreme Court and Appellate Circuit precedent has diminished the already sparse usage of this doctrine. A better solution for defendants suffering from the burdens of multiple hung jury retrials will need to avoid contrary precedent and address the competing interests involved in deciding to retry the defendant. Enter Rule 29. Part 2. Rule 29. Part 2 introduces Rule 29 as a potential solution to prevent undue retrials after a hung jury. First, it explains the mechanics of the rule based on its plain text. Second, it analyzes how the rule is currently applied by courts. Right. So, we've got the plain text. Rule 29 of the Federal Rules of Criminal Procedure, motion for a judgment of acquittal, has three parts relevant to hung juries. 29A statute allows the defendant to move for acquittal after the government closes its evidence or after the close of all the evidence. So this is like a directed verdict, similar or something. 29B allows a district court judge to delay ruling on an acquittal motion until after the jury is discharged, even if the motion was made before the discharge. And 29C allows an acquittal motion to be made before or after a jury discharge. So even after a jury is discharged, you can still acquit. Even after the jury is discharged, the judge can still acquit. The rule states a judge must enter a judgment of acquittal of any offense for which the evidence is insufficient to sustain a conviction. If a district court judge finds insufficient evidence to sustain a conviction, the judge has no choice but to acquit. On its face, this standard appears to give relief to defendants facing retrial after a hung jury mistrial. A hung jury is indicative of insufficient evidence to sustain a conviction because the evidence was already insufficient to sustain a conviction at trial. Makes perfect sense to me. By failing to convince all jury members that conviction was warranted. Yet, this is not how the insufficient evidence standard has been applied. B. The current insufficient evidence standard. Rule 29 gives a judge no guidance in determining whether there is insufficient evidence to sustain a conviction. Thus, the standard is a judicial creation first articulated in Jackson versus Virginia. Justice Potter Stewart stated that to determine whether evidence is sufficient, the relevant question is whether, after viewing the evidence in the light most favorable to the prosecution, any rational trier of fact could have found the essential elements of the crime beyond a reasonable doubt. So, okay. So instead, you're looking at it as if any one of them could find her guilty, then that's the standard that I'm going for. If a reasonable person, having looked at all of the evidence, could convict beyond reasonable doubt, then you must favor the prosecution, I guess. I don't know. All right, so what once looked like a favorable standard for defendants facing retrial post-hung jury was given a pro-prosecutor facelift, tilting the balance of evidence in the light most favorable for the government. As if this deference was not difficult enough to overcome, federal courts have also unanimously decided to apply the same standard regardless of the jury's verdict or lack thereof, meaning a hung jury has no bearing on the standard whatsoever. Thus, even if the jury fails to agree on whether the evidence is sufficient to convict, as is required to sustain a conviction, the court is not allowed to view that failure to convict as indicative of insufficient evidence. I think that it should mean that because the evidence put forth at trial did not result in conviction. Therefore, insufficient. I mean, why is that so hard to understand? Why is the law so difficult? I don't get it. Everybody's got to interpret things different ways, and it's so crazy. The Jackson standard is particularly harmful when applied to cases that result in hung juries, as it creates an unabridged mismatch between how the jury and judge analyze the evidence. A jury can only convict a defendant if each and every juror finds the defendant guilty beyond a reasonable doubt. Yet, the, the Jackson standard emphasizes that a judge must deem the evidence sufficient to convict if any rational trier effect. So if just one person finds it reasonable, then I win. If one person finds it reasonable, any trier of fact could find the defendant guilty beyond a reasonable doubt when viewing the evidence in the light most favorable to the government. The gulf between how any rational trier of fact could view the evidence when forced to look at it in the government biased light, and how a jury of 12 rational triers of fact actually views the evidence in an unbiased light can be enormous. If you look at it in an unbiased light, yes, it can change tremendously the outcome. So this creates a hole in the Rule 29 acquittal process when applied to hung jury cases. Sorry, so many footnotes there. As evidence in the light most favorable to the government may appear sufficient for any single juror to convict, but in reality is too weak to convince any group of 12 jurors to ever convict, theoretically allowing endless hung jury retrials. Since the Jackson standard does not change no matter how many times a jury hangs, defendants trapped in this legal hole, it's like a loophole, an endless loophole of retrials that they can just keep coming at you, and they have no way to defend themselves or get themselves out of that situation. It's unreal. United States versus Penn. The subject of this note's introduction exemplifies how insuperable the current insufficient evidence standard really is. Even after multiple hung juries. I'm like trying to say hung or hang. I'm like, which version of it? Multiple hung juries. As stated previously, the first two trials of broiler chicken industry executives accused of price fixing resulted in hung juries. Recall that when the government stated that they were going to try the defendants a third time, presiding Judge Brimmer was not shy in expressing skepticism. Judge Brimmer seemed unconvinced that there was sufficient evidence to convict after two sets of 12-person juries failed to do so, as the conviction requires a unanimous verdict of a 12-person jury. Yet, when it came to applying Rule 29's insufficient evidence standard, these concerns about the hung juries not so mysteriously vanished. Judge Brimmer started his Rule 29 analysis with the standard every district court applies. Viewing the evidence in the light most favorable to the government, a reasonable jury could have found the defendant guilty beyond a reasonable doubt. So that's why he gets a third trial. Stupid. He then went through the charges against the defendants, never mentioning the past two hung juries when considering whether the evidence was sufficient. Viewing the evidence in the light most favorable to the government, Judge Brimmer found sufficient evidence for all of the charges because they're using the Jackson standard or whatever instead of applying this Rule 29 how it probably was meant to be applied. All right, so why was the result preordained? Wait. Viewing the evidence in light most favorable to the government, Judge Brimmer found sufficient evidence for all charges. The decision should be unsurprising. It was inevitable. Why was this result preordained? Because the judge had already concluded the evidence was sufficient 4 months prior. So the defendants had previously moved for a Rule 29 acquittal when the first trial resulted in a hung jury, and Judge Brimmer, undertaking the same analysis he would later conduct in response to the second motion, found it sufficient evidence. So because you have to look at it in favor of the government, these institutions can just keep coming after people over and over again. It's garbage. This shit needs to stop. So infuriating to me. All right, so the current standard, which forces the judge not to consider past hung juries as indicative of insufficient evidence, essentially forced Judge Brimmer to repeat the same analysis on the same evidence. It was a meaningless exercise. It is absurd to think that the government would somehow produce less sufficient evidence in a retrial they had more time to prepare for, especially when their evidence was already deemed sufficient in the first trial. A Rule 29 standard that forces judges to ignore hung juries is indicative of insufficient evidence and nonsensically repeat the same analysis every time a jury hangs is not functional. It's time to fill the hole in Rule 29. Part 3. A new Rule 29 standard. This note argues for a new Rule 29 standard that allows judges to consider a hung jury as indicative of the government's inability to provide sufficient evidence to sustain a conviction, because that's what it really is. The proposed revision to the standard is simple. After a jury fails to convict, the judge should use the same Jackson standard for determining sufficiency of the evidence, except the judge will no longer be required to view the evidence in the light most favorable to the government. Thus, the only inquiry the judge would make in determining the sufficiency of the evidence after a hung jury is whether a reasonable jury could have found the defendant guilty beyond a reasonable doubt. So instead of using that standard as to if any one person could do it, then it's valid. Change it to if a reasonable jury could all come together and find her guilty, then okay. But if not, not enough evidence. The main benefit of this new standard is that it allows the judge to consider all the evidence it has at its disposal when determining whether the evidence was sufficient to convict. First, the judge can consider a hung jury as probative evidence that a reasonable jury could not have found the defendant guilty. This is not to say the judge is forced to consider the hung jury as definitive proof of insufficient evidence. If the judge has reason to believe the jury was not reasonable, the judge has full discretion to allow a retrial. Yet, even in this scenario where the judge disregards the hung jury entirely, the new standard at least allows the judge to make that determination rather than forcing the judge to turn a blind eye to the possible suggestion of insufficient evidence that a hung jury provides. Like like I was saying, what's the point of a judge being there if they can't use their brain and make decisions based on the evidence in front of them rather than precedent, the way we've always done it? Look at the evidence in front of you and make a decision. I mean, what a concept, right? Yet, even in this scenario, where the judge disregards the hung jury entirely, the new standard at least allows the judge to make that determination rather than forcing the judge to turn a blind eye to the possible suggestion of insufficient evidence that the hung jury provides. Second, by not limiting the judge to view the evidence in the light most favorable to the government, the new standard allows the judge to balance the parties' interest when deciding Rule 29 acquittals. In determining whether a reasonable jury could have found the defendant guilty beyond a reasonable doubt, the judge could balance the chance a new jury will find the defendant guilty, the government's interest in a retrial, and the burden a retrial has on the defendant. Not just that, but the state too, and the taxpayers. Like Karen Reed, I'm sure that trial cost a lot of money for Adam Lally and Michael Morrissey to prosecute that case. But and then it ends in a hung jury. And now you want to do it again? The taxpayers of Massachusetts have to pay for that all over again. So not just the defendant, but also the state has to pay. This balancing accounts for the interests of the public and the defendant when deciding whether to acquit, interests that are not given appropriate weight under the current Rule 29 insufficient evidence standard. While a significant shift on paper, this balancing already seems to be happening behind the scenes. One more pen is illustrative. Before conducting the third trial, Judge Brimmer summoned Assistant Attorney General Jonathan Cantor, head of the DOJ's Antitrust Division, to have him explain to the court why the government thought they could still win convictions after two hung juries. It clearly annoyed Judge Brimmer, emphasized how burdensome a third trial would be. If the government thinks that the 10 defendants and their attorneys and my staff and another group of jurors would spend 6 weeks retrying this case after the government has failed in two attempts to convict even one defendant, then certainly Mr. Cantor has the time to come to Denver and explain to me why the Department of Justice thinks that that is an appropriate thing to do. That takes balls, Judge, to be like, hey, person at the Department of Justice, come here and tell me to my face. That's pretty funny. The government, not wanting to annoy the judge any further, subsequently dropped charges on 5 of the 10 original defendants. This simplification of the case likely increased the probability of a conviction and likely made Judge Brimmer more comfortable proceeding with the case. Of course, much of this is speculation. None of these comments or weighing of the burdens and benefits of a retrial made it into Judge Brimmer's Rule 29 ruling, as the standard prohibits any such weighing of evidence that would not be in the light most favorable to the government. So this is just a what if. Yet, despite the standard prohibiting such balancing, it is hard to imagine that these concerns did not factor into Judge Brimmer's analysis, and it is interesting to wonder whether he would have miraculously shifted his perspective on the sufficiency of the evidence had Cantor refused to meet with him, or if 5 of the 10 defendants were not dropped from the case. So the DOJ dropped it, but would the judge have dropped it if or dismissed the charges, acquitted um or them, whoever them, multiple defendants? If would Brimmer have acquitted them and dropped the whole case if the DOJ hadn't dropped the case on 5, but they only dropped it on 5 of the 10. Um, so whether or not these DOJ concessions played a part in Judge Brimmer's ruling, it is clear that the current standard does not allow a judge to overtly balance all of the benefits and burdens of a retrial. The proposed new Rule 29 standard avoids this smoke and mirrors act. Instead, a judge may explore all the evidence openly when deciding whether it is appropriate to allow a retrial after a hung jury. I mean, give them some authority, give them some autonomy to make that decision instead of saying, well, we got to do it this way because that's how it's always been done. Think logically and make a decision based on that. That just makes sense to me. Application to states. While this note has focused on federal courts, the proposed new Rule 29 standard could apply to state courts as well. Certainly, at least 28 states explicitly allowed judges to acquit defendants after a hung jury. 28? Is that what I said? 28 states allowed judges to acquit a defendant after a hung jury mistrial. All 28 of these states use an insufficient evidence standard that is identical or functionally equivalent to the standard in Rule 29. And courts in all these states apply the Jackson light most favorable to the government standard, meaning adopting the new proposed insufficient evidence standard could greatly benefit the defendants in these cases. And why can't you do like we're going to change the way we're doing it now, but we're not going to go backwards? Because if that's what they're worried about, like they could make some kind of statement like going forth from this point on, instead of like going backwards into the other cases. I don't know. For defendants left in the lurch of undue retrials post hung jury, the impact of a new insufficient evidence standard could be even greater in state courts than in federal courts. The federal court system only has roughly 3,200 criminal trials per year, while the state court system has roughly 54,000 criminals. That's a lot more. State courts also have a hung jury rate of 6.2, more than doubling the federal hung jury rate of 2.1 to 3. This means that a new insufficient evidence standard for hung jury mistrials far more would have far more application in state courts than federal courts, increasing its overall impact. Beyond the general statistics application of the proposed insufficient evidence standard in state courts would have in, the standard in state courts would have an immense impact on individual defendants facing multiple hung jury retrials, as states seem to be more willing to retry defendants over and over again. And why? It's another expense, too. It just doesn't make sense. Curtis Flowers' saga is a salient example, and I mentioned him earlier in my show as how he was charged Mississippi. That's it, 6 times. And he was sentenced to lose his life. Flowers was charged with capital homicide in Mississippi. His first trial resulted in a conviction, and he got the DP, but was reversed and remanded by the Mississippi Supreme Court due to several instances of prosecutorial misconduct. Throughout the trial, the prosecutor had impermissibly referenced crimes irrelevant to the case, asked baseless, impeaching questions during cross-examination, and alluded to unadmitted evidence in their closing argument. Adam Lally gave lies in his argument, all of which cumulatively prejudiced Flowers' right to a fair trial. His second trial also resulted in a conviction, and he got the DP again, but it was reversed due to the same prosecutorial misconduct at the first trial. The same prosecutor in every single one. The prosecutor again impermissibly referenced other crimes irrelevant to the case, asked baseless impeaching questions during cross-exam, and again alluded to unadmitted evidence in their closing statement. Flowers' third trial again resulted in a conviction and DP, and again was reversed and remanded due to prosecutorial misconduct for a third time. Same prosecutor. This time for using preemptory strikes in a racially discriminatory manner. So now this guy has gone 3 times after Curtis Flowers. First 2 times, prosecutorial misconduct. This second time, more prosecutorial misconduct, but specifically, they used their strikes of the jury to get rid of people of color. And Curtis Flowers is black man. So, yeah. He was then tried a 4th time, resulting in a hung jury. He was tried a 5th time, the jury hung again. Could you imagine going through this? Could you even imagine one trial, let alone 6? He was tried a 6th and final time, resulting in a conviction, and he got the DP again. Flowers appealed, arguing that he should be acquitted based on insufficient evidence to convict. Intuitively, one would think the procedural history above should matter, as it shows a string of prosecutorial abuse and jury indecision. The state had previously been given 5 chances to convict Flowers, yet it could only secure convictions through manipulating either the jury's perception of the evidence or the composition of the jury itself. It's very telling. When those prosecutorial abuses stopped, so did the convictions as seen by the 2 hung juries. All of this indicates that the evidence was insufficient to convict. Yet the Mississippi Supreme Court ignored it all. Like federal courts, Mississippi courts used the Jackson insufficient evidence standard, viewing all evidence consistent with the defendant's guilt in the light most favorable to the state. Thus, the Mississippi Supreme Court simply reviewed the prosecution's evidence and determined that, in the light most favorable to the prosecution, it could support Flowers' conviction. There was no mention of past prosecutorial misconduct, no mention of the past two hung juries. All that mattered under the Jackson insufficient evidence standard was whether the state had provided evidence that, when viewed in an isolated, biased light, could support the conviction. Under that deliberately selective analysis, Flowers' conviction and DP were upheld. Are you kidding me? Or at least upheld for the moment. Flowers appealed to the U.S. Supreme Court, and the court found that the prosecutor had once again impermissibly used preemptory strikes in a racially discriminatory manner during their jury voir dire. The conviction was, for the fourth time in 6 trials, reversed and remanded. The prosecutor was given full discretion to retry the case again, but rather than subject Flowers to a 7th trial, the state gave up. It dropped the charges, citing a lack of credible witnesses. It took 6 trials over 23 years for the state to admit it lacked sufficient evidence to convict, when we knew that after the first. This is ridiculous. Prosecutorial misconduct and um, lies. I mean, just the way that they're coming at them, I can't even imagine. And I have a feeling the Commonwealth would keep trying Karen Reed as many times as necessary to get it guilty because they want so badly to win. I don't get why it's like a competition between the prosecution and the defense. Rather than subject Flowers to the 7th trial, the state gave up, dropped the charges. It took 6 trials, 23 years before they admitted insufficient evidence. Flowers spent nearly all of those years in pretrial custody, awaiting seemingly endless retrials. So, pretrial custody, he was in jail most of that time. Yet, despite the continuous prosecutorial misconduct and multiple hung juries, the decision to retry Flowers was never taken out of the prosecutor's hands. The Jackson light most favorable standard blinded judges from seeing anything outside the evidence the prosecutor presented, allowing a prosecutor who had been found multiple times to have engaged in misconduct and repeatedly failed to convince a full jury of Flowers' guilt to decide his fate. Flowers' case is egregious, but not an anomaly. Professor Leonetti notes that multiple retrials of defendants after hung juries in state courts happen relatively often due to the virtually unbridled charging discretion afforded to prosecutors. They happen often. Retrials of people who already were on trial and the jury couldn't reach a verdict. The current light most favorable standard does nothing to check this unbridled prosecutorial discretion, only an insufficient evidence standard that allows a judge to view the evidence in a neutral light, weighing the comprehensive benefits and burdens of a new trial can counteract this prosecutorial abuse and provide relief to defendants. That is pretty well spoken there. It makes perfect sense. Why are we looking at it in favor of the government when you're on trial, the defendant has the favor? Everything's more favorable to them. The judge is supposed to look that way, but it doesn't always. But so she's using Karen Reed as an example. So she's still not convicted technically, but the charges are still there. So what is it? Like she's kind of in a limbo, and it sucks for her. It sucks for anybody that's in that limbo stage, and then you got to wait for the state to say, "Yes, we're officially charging you again," and here they come and blah blah blah. So, like, it's just such undue stress and such a burden on people when this occurs. All right, so part 4 or 5 addresses 2 potential critiques. All right, I'm not going to read all that. We'll learn what part 5 is as we read. A disregard for precedent. One might argue that this new standard disregards long-standing precedent on how to determine whether evidence supporting a conviction is weak enough to warrant a Rule 29 acquittal. Yet a closer reading of cases where the insufficient evidence standard finds its origin is illuminating. This history shows that the current standard is not only inapplicable to hung juries, but also fails to abide by its purpose of preserving the jury's fact finding role. Exactly. The finders of fact found that they couldn't all convict. So, therefore, you didn't prove your case. So, isn't that the fact? That they didn't prove their case. So, why should they keep getting more chances to go? Um, Da, 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 da. I forgot where I was or lost my place. This history shows that the current standard is not only inapplicable to hung juries, but it also fails to abide by its purpose of preserving the jury's fact finding role. The standard currently used comes from Justice Stewart's opinion in Jackson versus Virginia. Yet Justice Stewart's reason for adopting the standard was based on preserving a jury's guilty verdict and is thus wholly inapplicable to the context of a hung jury mistrial. In explaining why a judge must view the government's evidence in the light most favorable, Justice Stewart stated that once the defendant has been found guilty of a crime charged, the fact finder's role as weigher of the evidence is preserved through a legal conclusion that upon judicial review, all of the evidence is to be considered in the light most favorable to the prosecution. Glasser versus United States, the case cited by Justice Stewart as the originator of the light most favorable requirement, also emphasized the fact that the jury came to a verdict when establishing the standard. The verdict of a jury must be sustained if there is substantial evidence, taking the view most favorable to the government to support it. A hung jury is not a verdict. Rather, it is the failure to come to a verdict. This means there is no verdict to preserve or sustain that requires a court to use such a favorable standard for the government. Bingo. Look at that. If courts are truly supposed to preserve the fact finder's role as weigher of the evidence, then they must respect a jury's inability to reach a verdict. Right. Like, why aren't you respecting the fact that they cannot convict her? As the district court in Ingram concluded, there is great deference shown jury determinations that result in conviction, and the same attitude should prevail when members of a jury disagree so conclusively. Yet the current standard, enforcing courts to look at the evidence in the light most favorable to the government, prevents courts from even acknowledging the jury's inability to reach a verdict. To preserve the jury's fact finding role as Jackson demands, the insufficient evidence standard must respect a jury's failure to come to a verdict by considering that failure in its insufficient evidence analysis. Exactly. Why aren't we considering that? Only a standard that drops the light most favorable requirement allows a judge to preserve the jury's fact finding role in trials that result in a hung jury. Isn't this fascinating? I'm sold. I think this is the way we should be doing things, but I think that there's a real problem in how we're doing it now. So, all right, B. Reinterpreting longstanding precedent does not work. Another counter argument is that the proposed reinterpretation of Rule 29 will not be accepted by appellate courts. The Jackson insufficient evidence standard is longstanding precedent used by every federal circuit and district court after a hung jury. As seen in Part 1's discussion about failed attempts to reinterpret the Double Jeopardy Clause's application to hung jury retrials, federal appellate courts are not fond of overturning longstanding precedent even if the original reasoning is faulty. However, a new insufficient evidence standard does not implicate appellate courts whatsoever. What makes revising the Rule 29 standard different from reinterpreting the double jeopardy clause or inherent authority jurisprudence is that unlike a Rule 29 acquittal following a conviction, a post hung jury Rule 29 acquittal cannot be reviewed by an appellate court. The Supreme Court in United States versus Martin Linen Supply Company held that any review of an acquittal after a hung jury mistrial would violate the Double Jeopardy Clause. Furthermore, the Supreme Court has consequently held that this bar on retrial remains in force even if the acquittal was based on legal error. Thus, the impenetrable Double Jeopardy Clause doctrine that spurns defendants facing hung jury retrials becomes a defendant's greatest weapon under the proposed new Rule 29 standard. If a district court judge acquits a defendant after a hung jury on Rule 29 motion, appellate courts are powerless to change that acquittal even if they disagree with the insufficient evidence standard used. Mic drop. I think this is an excellent paper. I may not understand all of it, but I definitely get the gist of it, and I think it's awesome. And I love where they're going with it. I love the thought process of, let's not just do things the way we've always done it just because we've always done it that way. Let's take a look. Let's use our heads. Let's make things better. Like, why are we not trying to improve? Isn't that what we should all be doing? Improve our justice system. All right, so this is the conclusion. We're almost done. All right, so legal scholars, judges, and defendants alike have all sought ways to prevent the government from unduly retrying defendants after a hung jury. First, they looked to the Double Jeopardy Clause, but the small and cryptic Perez opinion that declared hung jury retrials is not, uh, uh, sorry, but the small and cryptic Perez opinion that declared hung jury retrials to not implicate double jeopardy proved too far reaching and durable to overcome. Then they overlooked the judge's inherent authority to stop undue retrials. In return, the Supreme Court established a strict test under Dietz that made using such inherent authority to stop hung jury retrials all but impossible. Finally, they turned to Rule 29. Despite the promise carried in the rule to met out justice to defendants, an insufficient evidence standard that gives no regard to hung juries and is heavily tilted in the government's favor currently stops these efforts. It does not have to be this way. Rule 29 gives no standard for how to determine the sufficiency of the evidence. The Jackson light most favorable to the government standard is not applicable to hung jury retrials, and the appellate court's unwillingness to change this standard is no obstacle due to the unappealable nature of post hung jury acquittals. Courts need not be at the mercy of the government when deciding whether to conduct a retrial after a hung jury. We end where we begin with Penn. In his hearing after AAG Cantor, Judge Brimmer asked what stops the DOJ from continually trying defendants after a hung jury. How many times does the department say, "We believe in our case," as opposed to, "Let's look at the evidence"? Cantor responded that he believed justice will be served by having another trial. Though a nice sentiment, this note contends that an impartial judge, not the government, should decide whether yet another trial will serve justice. A new Rule 29 insufficient evidence standard that allows judges to review all the evidence in the light in which it is actually seen by the jury, while balancing the benefits and burdens of a new trial, would better ensure justice is served. And I agree with that. I believe justice would be better served if we're not just retrying and retrying and retrying people that have hung juries. So I thought this paper was really interesting. It brings up some excellent points. It is actually a very current paper. It's 2024. This is from the Northwestern University Law Review. And you know what? If I can find the link of where I found this, I'll put it in the comments below so you guys can look it up and if you want to reference some of these cases, you could feel free. So I thought it was interesting. I thought that it brought a lot of things to light. And I think, you know, we should always be looking at ways to improve and streamline the way that we're doing things. Coming to the 21st century, first of all, for courts everywhere, let's get some Zoom feeds on YouTube channels or wherever, and let's start having all hearings and, court cases, trials put on. We should be live. We should be able to, at any point, like, I live in this town, I'm going to click on that town's thing, and here's the courts for that day, and I should be able to see it. I mean, we're in the 21st century now. We should all have that capability instead of, getting your butt down to court. I think um, all courtrooms everywhere should have cameras. Police everywhere should have their body cams on constantly. I think we're in that moment of technology where we can have it work for us and help us prevent wrongful convictions, help us prevent prosecutorial overreach. These are the things that we need to start being better at. So I thought that, bringing these arguments up, I know it's not a Karen Reed court document or anything, but I thought it was interesting just to kind of let you guys think about it in different terms. Is a hung jury, should that be a final verdict? Is that a verdict? Is a hung jury a non-verdict a verdict? I kind of think it is. You couldn't come to the decision, so therefore, state loses its case and charges should be dropped altogether. That's my opinion. Sticking to it. You guys let me know what you think in the comments below. Thank you guys so much for being here. I appreciate you immensely. Please hit that like button on the way out, and I will see you guys in the next one. Take care. Bye now.
If you've been impacted by a true crime and would like your story told in your own words, or if you or someone you know has been wrongfully convicted or accused of a crime, please write to crimeincourtchannel@gmail.com and tell us your real true crime encounters. Thanks for watching.